All right. Now, this is the second part of specific performance, where I will continue with the next principle governing specific performance. In the case of hardship and expiry of limitation period, it does not relinquish the right of the plaintiff to claim for specific performance. In the case of R.M. Venkatalachalam, Chetya, and N.K.R. Anasalam Chetya, in this case, this involved sale and purchase of land, but there was a delay on the side of the purchaser, not because of his fault, but due to the delay of the Japanese government in assessing the tax. So due to the delay, the landowner has refused to execute the contract. The court held that because of the delay, the time to buy the land has expired. The court held that relating to the expiry of time or time bar, the action is not bar because it is not subject to the debtor and creditor ordinance. So time here is not of essence because the delay was not done on the part of the purchaser, but that was an external or outside the control of the purchaser because that was the government's delay or the assessor's delay. Secondly, the hardship suffered by the purchaser here for not performing the contract was not foreseen. It was unexpected because the delay of the tax assessment was beyond their control. Therefore, the court held that the plaintiff is entitled to the specific performance. Please have a look as well at the case of Haji Osman and Said Noor for the details of the principle. The next part of the lecture going to look into the reason why the court would not grant specific performance. Section 11 provides the situation where the contract can be specifically enforced. It says that the types of contract eligible for specific performance can include the contract to perform trust, where the trustee, for instance, has obligation to make sure that the property is conveyed for the benefit of beneficiary. Secondly, it could be also in the case of the breach of contractual obligation, where the contract is not performed. Here, we can see that damages alone is not enough, or there is no certain way to ascertain the assessment or the calculation of damages. Thirdly, there is also breach of contract where monetary damages or compensation is not enough. And finally, where in the case of non-performance, monetary damages is not available. So the only way to enforce your right in a contractual obligation is by way of specific performance. This is what we discussed just now, particularly in relation to contract of transfer or conveyance of land, where damages shall be presumed to be inadequate. Therefore, the performance can be sought by the parties. In the case of Loh Kun Moy and Zaibun, the federal court was considering on this matter of transfer of land. In this case, the respondent, the estate administrator, you can consider that the respondent was a trustee in this case, initially agreed to sell some lands to the appellant. However, the respondent refused later to sell the land because of the oral agreement. And due to the termination of the contract, the respondent is willing or was willing to pay damages for the breach of contract. However, the appellant refused to accept the damages and sued for specific performance. In this case, the court allowed the appeal. Therefore, the presumption in section 11 subsection 2 was not rebutted, meaning that in any cases involving transfer of land or contract involving land, purchase, sale and purchase, damages can be presumed to be not enough because that is the statutory presumption. Therefore, in any situation for the land sale and purchase contract, you can always rely or apply for specific performance as a remedy together with damages. Section 11, subsection 2 is the statutory presumption where damages are presumed to be not enough. However, the defendant can rebut the presumption. For instance, if it can be proven that there was hardship and delay on the part of the applicant, or there was an element of voidable contract like fraud, undue influence, misrepresentation or mistake, or in cases where there are illegal or unlawful contract. So if in any of these instances are present in the case of land transfer, you can say that damages are enough to be granted in favor of the plaintiff. So there is no need to proceed with the specific performance. In the case of Hong Ah Kim and Paya Trubong Estate, Section 11, subsection 2, the court said does not apply, where it may be difficult due to changes in the area of the said land for the parties to agree on the particular allocation to be demarcated for subdivision for alienation to the plaintiff under the agreement. In this case, the court held that damages are enough, so there is no need to apply for specific performance because of the complexity of the transaction. In the case of Sekemas Lian Berhad and Lian Seng companies, Lian Berhad, in this case, there was a land purchase worth 15.1 million. The defendant failed to settle the remaining balance of 4.5 million. Therefore, the plaintiff sued the defendant for specific performance, sued the defendant on the ground of breach of contract and claimed specific performance as a remedy. In this case, the court said that the defense of hardship is not available for the defendant because the fault was done by the defendant himself for not assuring that he had sufficient money before starting the project. Therefore, the court held that the defendant failed to prove that damages is enough. That's why in this case, apart from claiming for the sufficient or remaining balance of the contract, the performance is also granted to the plaintiff against the defendant. The next part is when we will discuss on the situation where contracts cannot be specifically enforced. In other words, where specific performance cannot be granted to the parties. For this reason, we refer to section 20, subsection 1, clause A to H. Okay, let's look at first at the clause A, where it says that a contract for non-performance of which monetary compensation is an adequate relief. This is the situation where, if you look at the contract, damages is enough to the parties. For this reason, we read together with section 11, subsection 2, if the transaction involve land transaction or land SPA, sale and purchase agreement. So if that happen, in the case of land, you cannot say that monetary compensation is enough, especially for the land related matters or land related dealings. In the case of Adderley and Dixon, the court said that why is that so? Why there is a statutory presumption that damages is not enough? Because land itself has a peculiar and special value. Therefore, the plaintiff may not recover the right only by way of damages, but need to fulfill the right of the plaintiff also for specific performance. Secondly, specific performance cannot be enforced where it depends on the personal qualification or volition of the parties. For instance, you can look at the illustration under the section when the plaintiff has died. The plaintiff is a rare or artist, for instance, but because he has passed away, it is very difficult to enforce performance. So in return, damages here would be the only available remedy for the plaintiff. Or where you see that the defendant has suffered disability due to accident. So it is difficult on the part of the defendant, or it is the hardship on the part of the defendant would make the defendant impossible to perform the contract between him and the plaintiff. The third situation is where the court cannot find reasonable certainty within or with the terms of the contract under Section 21C. So in the case of Lin Nhu Chan and Wong Zi Sin, in this case, the tenancy agreement failed to clearly mention for variation of rent because there is modification of rent there. So the uncertainty here, however, is not related to what the contracting parties had agreed to do. The uncertainty relates to how frequently the current rent should be varied and how the rent should be determined. Hold on. I'm looking for the slide because I could not see quite clearly from the screen. So the court held that the uncertainty is not related to what contracting parties had agreed to do, but the uncertainty here relates to how frequently the current rent should be varied or modified and how the amount of variation is to be determined. So the lack of clarity in the tenancy agreement is the situation where it would be impossible to enforce the contract by way of specific performance. So damages only the available remedy to the plaintiff. Another situation where specific performance cannot be enforced is when the nature of contract is irrevocable contract. You can have reference to the illustration under section 20, clause 1, 20 subsection 1, clause D. Let's have a look at the section. Just a minute, I'm referring to the statute. Section 20, subsection 1D. Right, let's scroll down a bit into the section. You can have a look at illustration D for the details here. Where for illustration D, in this case, because of the failure of the promoter of the company of not taking proper precaution to ascertain the value of the property, that has caused the payment of unnecessary or exorbitant price of the property. They stipulate that the vendors shall give them a bonus out of the purchase money. The problem is that because of it cannot be revoked. It is a revocable contract, therefore it cannot be enforced. In this illustration, the promoters of a company for working minds contract that the company shall purchase certain mineral property. The problem here in this case, they had not done a proper valuation of the property, and because of that, they issued a price of the land which is inappropriate. So here, the contract cannot be specifically enforced because of the revocable contract. Next, where a contract is made by trustee either in excess of their power or in breach of trust. Next is where contract made by or on behalf of a corporation of a public company created for special purpose which is in excess of its power. So for the matters that the trustee or the company made a contract which is beyond or ultra virus, that cannot be enforced by way of specific performance. You can only enforce something which is within the power of the trustee or within the power of the corporation, here of a public company or public corporation. In the next situation is where the performance of the contract involves the performance of continuous duty over 3 years from its date. So meaning that the contract is conditional contract. If the contract is not yet finished or dependent on other subsequent conduct, that would not be possible to pursue under passive performance until the duty is carried out over the period. The next part is when the next situation is where a material part of the contract has ceased to exist. This is where you see that this is the contract has caused frustration into the fundamental content of the contract. So that would not be able to perform the contract if it has frustrated the contract as a whole. There is no need. So the only available remedies for this situation is by way of damages. That's all for specific performance. If you have any questions, please feel free to ask in our next class or in our YouTube channel. Thank you so much for your time and have a good day. Assalamualaikum warahmatullahi ta'ala wabarakatuh.
Thank you, Doctor.
Welcome.